NACDL is the association of the nation's criminal defense bar.
The use of coerced confessions, whether true or false, is forbidden in our criminal system because the methods used to extract these confessions are methods against our accusatorial system. This is a system in which the state must establish guilt by evidence independently and freely secured and may not, by coercion, force it out of the accused. So said the United States Supreme Court 60 years ago. The use of coerced confessions, whether true or false, is forbidden. I am here to urge you to take back the Fifth Amendment. Take it back for our guilty clients, because they, just as much as the innocent, are allowed the Fifth Amendment. And so that's what this talk is about. It's about taking back the Fifth Amendment for the not-so-false confessions, for those that are true, for those that are mostly true, for the vast majority of our guilty clients. Before we begin, by a show of hands, how many of you wonderful practitioners would estimate that at least 60% of the confession cases you have reviewed are those made by guilty clients or clients who are at least partially guilty? Show of hands. How many would say the number is even higher, 80%? Keep your hands up if you think the number is at least 90%. Okay. So for most of us, the vast majority of confession cases are those made by folks who are at least somewhat guilty of the charges. This is a story. For the next hour, we're going to talk about how to litigate, how to take back the Fifth for those coerced confessions out of the mouths of our guilty or somewhat guilty clients. We'll begin by talking about the rates of false versus true confessions. Then we'll talk very briefly about the law. And finally, we'll end by using a case and applying what we have learned from our brothers and sisters in the innocence movement to a not-so-false confession case. So what are the rates of false versus true confessions? Well, the truth is, it's really hard to get at this. Researchers disagree. They disagree about whether they can really get at the number of false confession cases. They disagree about what that percentage is. We know from the National Registry of Exonerations that about 25% of exonerees gave false confessions. That doesn't tell you exactly what the number is, because as all of you know, there are cases that aren't as high profile, right? There are the drug cases and the misdemeanor cases, cases where our clients are being held, and in exchange for their freedom, they plead guilty. There are a couple of studies done to try to get at the rate of true confessions. And these aren't perfect studies because it's really hard to get at this. 2004, a couple of Icelandic studies were done by Johnson and a few other researchers and experts in the field. Here's what they did. They asked college students, 18-year-olds, young people, how many of them had been arrested. And of those that had been arrested, they asked them to tell them whether they'd been interrogated, and if they had, whether they had falsely or truly confessed. In other words, whether they were guilty or innocent. Here's what they discovered. Of those that had been arrested, about 59% had given confessions. And they were guilty of the crimes with which they had been charged. So true confessions. About 3.7% of those who'd been arrested and confessed had given a false confession. Now, these were young folks. The mean age was 18. And this was based on a self-report. So again, not a perfect study, but you start to get at the numbers, right? Just like the survey that we just took here. They did another follow-up study with a slightly older population, 25-year-olds. Pretty similar rates. The rates of false confession dropped to about 1.7%. And then our own random survey, right? So now we start to understand sort of the scope of what we're talking about. And we're gonna use these numbers to take it back, because I'm here to urge you, just as Steve Drizzen did, to file those suppression motions as you already have and to tell the story. And we're not gonna tell the story the way that they want us to tell the story. We're not gonna use a checklist. Our clients are not checklists. This isn't about a totality test. This is about the story. What is the law of voluntariness? Just very briefly, as you all know, this is about coercion. So we're not going to talk about Miranda right now. That deserves its own session. But the test generally is, has the accused's free will been overborne by coercive police conduct? Free will, what does that mean? Well, for all of you who have seen these confessions over and over again, or who have read them, or whose clients have told it to them, free will, it's when the narrator's voice changes from that of your clients to that of the detectives. Mark those moments. Maybe they don't elicit the kind of outrage they might in an innocent client because you don't have that fact feeding. But these voices change. They change in every single confession. That's because the detectives walking into the room have information your clients don't, and they feel the need to get it from them. Mark that moment, because that's the free will portion of it. Overborne by police conduct. So voluntariness claims require some kind of police action. And remember, it doesn't have to be the police as police. This could be a parent, as it was in one of my cases, co-opted into being an interrogator. Think broadly here, a cellmate co-opted into being an interrogator, an informant. Statements that are involuntary are suppressed for all purposes. This is why we got to take it back. Can't use them to impeach. They can't use them for substantive evidence. They can't introduce them against your client. They were illegally taken. And finally, and I think most importantly, and I sit here and I know you know this, the US Supreme Court law and the cases all over this country are just a mishmash. But the Supreme Court has recognized that coercion requires that coercion can be mental as well as physical. As one of its cases so beautifully put it, the blood of the accused is not required for coercion to be proven. The blood of the accused is not required because you're not going to see that. And if that's what judges are expecting, as many of them are, we need to educate them about what coercion means. That's your job. How are we going to do that? Let's take from our brothers and sisters in the innocence movement, right? Let's tell the story without the totality. There are 3 parts to this litigation that I hope I can urge you to focus on, as you probably already are. Induced confessions. We know from the research, we know from the innocent folks, that they confess to get out of prison. They confess because there is a threat implied or expressed against themselves, against their family. They confess to gain a reward. Guilty people do the same thing, and it's not okay to dangle these inducements in front of the guilty person either. And that's what you got to remind judges. So how do we really tell the story using what we've learned? Let's talk about Jimmy. 15-year-old Jimmy became my client shortly after another cold Chicago night. Many of these cases happen in cold Chicago nights. The rain was starting to turn into snow. 2 young teenagers walked down a pretty quiet street in the Austin neighborhood of Chicago. They weren't wearing coats at the time. You couldn't see the specifics of their faces, but you could tell they were 2 black, African-American teenagers. As they rounded a corner, they ran into 3 young men. For a second or two, one from each group talked to the other. And within seconds, the flash of guns rang out. There's no audio on this video. Everyone ran away. Now, one of those young men in the group of 3 lost his life. He was shot and killed on that night. 48 hours later, Jimmy, who would later become my client, sat in a 6x6 room. There was a cold metal bench, and there were 2 experienced homicide detectives. They'd been doing this for decades. Jimmy, this was his first time in an interrogation room. Now, he'd been previously arrested. So if we told this using the checklist, we'd just go down and say previous experience. But there's no experience there. He had never been interrogated before, and certainly not by these guys. Mother came in and out of this room. He was interrogated over the course of 36 hours. Now, he slept for a good portion of it. But here's what rankles. He would sleep. 2 hours later, detective would shake him, wake him up, ask him just one last question. Sleep again, 4 or 5 hours. Shake him, wake him up, ask him just one last question. So this wasn't really sleep, right? This was sleep deprivation. So how do we tell Jimmy's story?
What?
I don't know if you want to keep going on with that or tell the truth, but he lay out there.
Okay. So, since you gotta leave, you're okay with a youth officer coming in here, or a juvenile officer then with us?
Yeah.
Okay, because that's just not, I mean, that's
That's gonna happen.
I mean, that's not, but just you, I mean, but that you know that, but you're okay with it though, that, you know,
He has to have a lawyer present,
That's up to you.
I mean, that's up to you.
I mean, y'all gonna do what y'all gotta do. Y'all job, I mean, it's up to him. I mean, I know somebody gotta be here.
Right.
Right, and since you, a family member can be here, that's why we get a youth officer.
Right.
Yeah.
But, did you want a lawyer present?
I mean, honestly, y'all finna work with him right now?
That's up to you.
I wouldn't, yeah, y'all finna work with him right now? Yeah. Is it gonna take hours?
What are you talking about?
I mean,
He's in here, like, just slow down. Like I told you before, he's not going anywhere within 24 hours.
Right. He's here for 24
Once you leave, because you have to leave, if we're gonna come back and talk to him, we have to have somebody that's a youth officer.
Right.
Him and I just can't.
right,
Yes, we're gonna talk to him. Eventually, maybe he's not telling the truth because you're here. I don't know.
right,
You know.
yeah.
Well, like Brian says, you mentioned a lawyer. If you want a lawyer, then we can't talk to him anymore. We're gonna go with what we got.
Yeah, I'm gonna go with just saying, that he wasn't there, and he said he wasn't there, and that's fine, but we have a lot of stuff, that's gonna blow up his world. So that's up to you. If you want a lawyer present, then that's up to you.
Then we don't talk.
But if you want to let us talk to him, if you leave, and then that's up to you, and say, it's okay to talk to him without a lawyer. That's up to you.
It's up to you. Mom, who's leaving the room after he'd been interrogated already for the course of an hour. Mention a lawyer. Sure, we can say that's up to you, but guess what? And this is the message delivered to Jimmy. If he wants to stick to his story, we're going to destroy his world. We're going to blow it right up, right? Yes, there's a Miranda violation there, but I want you to focus on the coercion. What message does this statement begin with? Does this interrogation begin with? That his whole world is going to be blown up if he doesn't do and say what they want him to do and say. And that's the message that we need to keep relaying to the judges, that that's not okay. So what if it's a false denial, as these detectives believe, or even if there's objective evidence of that? That's not okay. And so here begins the coercion with a threat to blow up his world. How do these confessions, all confessions, interrogations work? Okay. Well, you've got, in the sports stories where you have this pattern of struggle, 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 lose, 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 struggle, 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 win, win, win. You got a pretty similar pattern in these interrogation cases. the true and the false ones, because detectives are trained in this. Confront, confront, confront. Accuse, accuse, accuse. Deceive, deceive, deceive. Scare into a feeling of total hopelessness. And then you're going to offer them a life raft. So focus on these moments. Find the confrontations. If it's an oral statement or a written statement, you know that more was said to your client than what is written down on the paper. Ask mom, ask client, ask over and over again, and ask the detectives. Find patterns. These detectives have interrogated others before. Confront, 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 accuse, 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 deceive, 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 scare.
You got to stay until you're 21. And you're 15 now, so that's 5.5 years. That's like a quarter of your life. Is it really worth a quarter of your life? No? Well, that's where it's going. So it's 5.5 years. Do you really want to gamble 5.5 years? Knowing that your last bit of freedom was this morning when you woke up. All that for when you didn't shoot. That's a lot to fucking gamble, dude. 5.5 years. Miss half of your 15, all the 16, all the 17, all the 18, all the 19, all the 20. Get them out. Then what? It's a long time to sit for not shooting a gun. A quarter of your life at that point will be spent blacked up. Your mother has to leave the kids and get to wherever she gets to try and see you for like your hour a week. Or your hour every 2 weeks. There's no pizza, there's no McDonald's, none of that shit. You're eating fucking what they give you. Here's a fucking ham sandwich. For 5 fucking years. When you didn't shoot the gun. All that because, no, that's not me. I wasn't there because these boys are lying on me and also the video's lying on me. I mean, think about that way, man. You're 15 years old. So that's like going from 10 to 15. You're going from 15 to 20, 21. 5.5 years. It's almost 6 years. 5.5 years. April, May, June, July, August, September, October, November. That's 2/3 of a year. So it's 5 2/3 of a year. 5 years and 8 months sitting in juvenile jail for not shooting a gun. Remember I said when you look back on this day, you're going to be like, man, how about a year from now? When you think to yourself, you're a year into this, knowing you've got another 4.5 years to go. You think you're going to say to yourself, man, I fucked up. 6 months from now, what are you going to say to yourself? When it's summertime. And there ain't no air conditioning. And you're sitting around with all dudes, all guys, for the next 5.5 years of your life, eating whatever shit they want to give you. For not shooting a gun. That's crazy. Giving up a quarter of your life as you know it. Fuck that. Fuck that. This last week, what'd you do by your sisters? What'd you do all day? You what?
He got a game.
She got a game? Yeah, what game?
PlayStation 3.
Well, there's no PlayStation 3. In jail. There's no PlayStation 3. There's no NBA 2K16 or NCAA 2K16 or 15 or 14. So how long will those days feel if you're sitting in a room and you got none of that shit? For 2,000 plus days. 5 years and 8 months is approximately 2,000 days. 68 months. 68 months, 2,000 days, however you want to break it down, that's what you're looking at right now. If you get charged.
If you get charged. So what's the point of this? Well, see, Jimmy was with, according to the detectives at least, the other teenager. It's the other teenager who shot that gun. But Jimmy, in order to be charged with that first-degree murder on an accountability theory, they had to show that he knew that other teenager had a gun. They had to show that he expected a fight to go down. And they had to show that he helped this other teenager dispose of the gun. And so whose voice is that on that video? That's not Jimmy's voice, right? Who is telling that story? Who is using his voice to confront the accused? And that repeats itself over and over. Now, he's not saying you're going to get the death penalty. Notice that this doesn't have to be sort of life and death. He's saying you're going to juvie jail, which, by the way, also a lie, because we all know they can transfer them, and often do, to criminal court. But he's saying 5.5 years, and to a judge, that seems, well, maybe not the worst offense, right? So you put the story together, and the confrontations continue over and over. You're not a good liar, man, you're not a good liar, and they ramp them up. You're making a poor decision, and really, truly, I hope you don't keep down this path. I hope you choose to go to the right path, because you're going to have a lot of time in this current path to be staring at cinder blocks and going, man, I wish I would have fucking told the truth, because this fucking sucks. This fucking really sucks, having to hear people scream all night long at the Cook County Jail. Now, this boy had just turned 15. He's in there alone. His mother has left. It's the middle of the night. What choice, what will does he have when you start to do this? You're playing a dice game, the most dangerous dice game of your life. It couldn't have been clearer. And the thing is, I know sometimes we don't get the videotapes. I know that. But this is repeated over and over. This is the pattern. You've got to uncover it. Talk your clients through it. So now you want me to get your sister involved in this, they say, right? Now it's a threat to the family. You want me to bring your sister here? Because we'll bring her in here. We'll bring her in here. You want the whole family involved? We'll get this whole thing going. We'll get this whole thing going, dude, and then. He leaves it at that. He doesn't have to say anymore. Even for my young, very disabled client, he doesn't have to say more than that. So how do we tell the judge why this matters? Count. Just like that detective counted, count them up. How many times was your client called a liar? How many times? Word lie doesn't have to be used, right? Just rejection of the story. Count them up and show them to the judge. This is what we did. How many times was his statement rejected? Count them up. Count them up and show them to the judge. How many times were the detectives demanding, threatening, and confronting your client into agreeing with their version? Count it up. Count it up, because that's when you start to see the narrator's voice shift. That's what free will means. It's no longer your client's voice telling that story, whatever story he's telling.
Hey, you think Taiwan is going to do the same when he comes in here for you? I don't know. This is on video. It's all on video, man. This is on video.
It's all on video. Remember what we talked about? How to tell this story? Confront, confront, confront. accuse, 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 reject, and now we begin to deceive. It's all on video, man. We got some evidence, and Laura and Steve talked about this because we see it in these innocence cases, and it's easy to see in the innocence cases. It's a little bit harder in the not so innocent cases, but it's there. It's all on video. There's fabrication, there's exaggeration. It's not all on video, at least not what these detectives are implying by that. What else do they say to him?
There's actually 3 mistakes you guys made that night. Number 1, you did it on a corner where there's a bunch of cameras. Number 2, you did it to a group of people who know you. And number 3, you dumped the gun in a garbage can on video. Those are 3 big problems. We are giving you an option here, because you are not the shooter, to explain what happened. There's a reason why you're here and Taiwan is not.
And I can tell you, there's another video that shows you in Taiwan walking down the street. Remember seeing there's a squad car makes a left turn and you guys are just walking down. I think you're coming up to Laramie, I don't recall. But you're sitting holding up your pants and you get the squad car turns around right past you guys. You remember that?
There's no video of a gun being dumped in a garbage can. That video doesn't exist. And yes, I know the cases that say that lies, deception, untruths, fabrications, all fair interrogation techniques, right? But let's educate our judges about when it crosses the line, when it's coupled with these confrontations and these threats and these promises and these deceptions and these rejections. Let's educate them about when it crosses the line. And let's ask our detectives during a suppression hearing about how many times they lied to your client and what those lies were about and why they felt the need to lie in the first place if their case is so strong. There was no video of the gun being dumped in a can. But of course they needed Jimmy to say that because otherwise it's pretty hard to prove that accountability theory against him. They got the mom to interrogate Jimmy and ask the same kind of questions. So the deception continues.
Do you know that is a camera out there?
What's that? Not a camera, camera.
Not a camera. Cameras, says the mom. So obviously they've had a conversation with mom beforehand. Now that's not captured on video, right? We had to do some investigation. We had to question the officers. We had to figure out what it is that they said to the mom beforehand. And they told her a story that was partially true and partially not so true. But what matters here is that they used the mom to interrogate Jimmy. That goes into this arc, this narrative storytelling. And then the real, and you have these in your cases. We've got the co-defendant here. We've got the DNA here. He admits he knows about the shooting, He also knew that. He said he knew you had the pistol because you guys were going to go over on some bullshit, looking for some revenge. What are they doing here? They're giving him the motive. They're giving him the motive. He's saying he had the gun, but if he knows, he said you knew he had the gun. That's all. Is that true? They're giving him the motive. They're telling him who the shooter is. They're telling him what they need him to say, that he knew about the gun, right? So there's a deception. They did not have the co-defendant saying any of those things. Lies. And our last part of this, of the story that we're telling, not a totality story, but rather the story of coercion. They scare him into hopelessness, not so hard to do when you've got a 15-year-old kid, and then they give him this life raft, right? The promises of leniency, an out. As long as he agreed to what they wanted him to say. What is it?
But the good thing for you is you didn't shoot the gun. Right. And you didn't shoot the gun. You're a juvenile. You're a juvenile who didn't shoot the gun.
That's huge.
Right? That's like slap on the wrist shit.
Starts, right? This is nothing. No big deal. You didn't shoot the gun. You didn't do anything. We're going to help you here. They're now offering him the life raft. Find these in your cases. What it's consent. There's a fight. We all know how upset we get. I've punched somebody in the past. Find these in your cases. Ask your clients about them if it's not on video.
Whatever. They have no trouble. They come in, and they're going to go, you're going to stand the lineup, 1 through 5. And then they're behind a window, and you're not going to know it. And let's say you pick number 2. So now you sit number 2. These guys know you. Guess what's going to happen? That's him. That's him. That's him. Now we have 3 people saying it's you. Now we have a video showing that you were there with the shooter. Okay? Now we have a video and 3 people. Chicago police detectives do not charge anybody with murder. Did you know that? Okay, I'm going to give you something here. The Chicago Police Department does not have the authority to charge you with murder. The Cook County State's Attorney's Office charges people with murder. So, what's going to happen is after you get picked out by these 3 people, and we're going to tell them, okay, and their first question to say is, okay, what did he say? Did he help himself out? Did he help us out here? No, he's saying he wasn't there. We show them the videos. Then they're going to ask, okay, did you guys do lineups? Yes. All the lineups were positive, meaning yes, you were picked out. Then they're going to sit and they're going to interview each and every person that viewed the lineup. Okay? After all that's done, guess what's going to happen?
Here's the ice.
There you go. Now we're going to be your friend. Now we're going to give you some help. You help us, we help you. This is a bond we can have together. Help yourself out, though. Help yourself out, though. And that's sort of the final piece of this. And I won't show you the videos, right? But obviously it's all about getting out, getting out, getting out. So much so that after Jimmy agrees that he in fact knew that his co-defendant had a gun, that he in fact knew and helped dump that gun, after that, the very first question out of his mouth, what do you think it was? Can I go home? Now I get to go home, actually. Wasn't a question. Now I get to go home, right? And that juvenile officer who's there to protect him said, I gotta ask about that. Next question out of Jimmy's mouth. Now do I get to go home? 3rd, 4th, 5th, 6th, we counted them, 7 times. 7 times. Now if that's not a contract, an agreement, an expectation, I don't know what is. They get it. The detectives get it. Now we got to get the judges, the prosecutors to understand this. That's not okay. That is forbidden. And the last one, here with the help of the mom. You tell them the truth, it can help you get out. It's explicit. It can help you tremendously, says the detective. So, first part, we're going to shape the narrative with the story we have. We're going to investigate if we don't have that videotape. We're going to talk about what it is that induces people to confess. Remember the sports story, right? Confront, confront, confront. Reject, reject, reject. Deceive, deceive, deceive. Hopelessness, and then the life raft. Going to find those moments and tell the judge about it. What's the next thing you need to do, though? The player in here. I'm going to talk about your client. And this is what I love about suppression motions. I know we all have cases where the evidence is really stacked against us, right? That there is a lot of evidence, corroborating evidence of your client's guilt. This is a moment to tell your client's story. Pre-trial, pre-sentencing, right? We're going to start to educate the fact finder about who our client is. What an opportunity to do this. Who is your client? How old is your client? It's not a checklist, right? It's not 15, 14, 17. What do we really know about his age? Does he act his age or does he act younger? What about psychopathology? There's plenty of research out there showing that anxious people, depressed people, people with serious psychiatric disorders are more likely to give coerced confessions. So figure it out. What is our client's history? Cognitive limitations, pretty big one, right? Let's educate the judge about what that means. Now, I was a public defender. So many of you are sitting here saying, we don't have the resources to do this. How am I supposed to call Iris in every single one of my confession cases? And it's true, we don't always have the resources. Sometimes we can't get the expert to do the testing we need. So go back, see what you can find out about your client. Try to get his school records, his individualized education plan records. Talk to his teachers, talk to his family. There's something there. There always is, or they don't show up where they are. History of trauma. Megan Crane, formerly at Northwestern Law School as well, wrote an article about this. This is really good stuff. Take a look at this. Childhood trauma and its lurking presence in the interrogation room. My gosh, how many of our clients have traumatic histories that we need to be talking about pre-trial? So you're investigating your client because obviously it takes less of the deception and confrontation to coerce clients with these kinds of risk factors. And here it is in Jimmy. He's young, disabled, unprotected, inexperienced, confused, tired. They got a perfect, vulnerable person to do this with. What did I say about going back and investigating their record, right? We went back, we got his individualized education plans, below age and expected level, below average level, severe deficits in the phonological component of language, unable to read, procedural deficits. IQ of 68, special education, can't read at all, can't appreciate rights, reads at a first grade level, which is barely. This was for the Miranda argument we were making, but it applies in the coercion context as well. And then we asked his family members. No, he had no idea what he was doing. He has a learning disability. Some doctor said something about MR. We asked his grandmother. He doesn't understand any of it. When I talked to him after court, he doesn't understand any of it. We asked his sister. He don't know what they said and couldn't understand words that were being used at the police station. These are the experts. These are the experts. Family members with whom your client is comfortable. These are the experts. And our third and final piece, think of this as sort of a tripod, right? You got the story, you got your client. Now we want to talk about the situational factors. What is the environment? Who are these interrogators? Who are they? Do they have a pattern? Turns out ours did. It wasn't another, but one of our interrogators had been accused of coercing an innocent person to confess. Try to get that in. Tell the judge about it. If anything, it starts to educate that fact finder about the credibility of that witness when they don't want to tell the truth on the stand. Where was the interrogation conducted? At school? At home? Or was it at a police station? For how long? Who was in the room? So, how do you investigate the interrogators? Find prior complaints against them. Any trainings that they've done? You can ask them on the stand, right? What kind of trainings are they doing? Are they using the READ technique? What do they know about the recent research? In our case, and we put this up for the judge, no evidence of juvenile trainings, nothing special about the warnings to account for Jimmy's age and limitations. They were standing over Jimmy. They lied during their testimony. And here's another thing. They knew about Jimmy's limitations because during that video, one of the detectives said, trying to get him, in the same way as you saw in the Brandon Dassey video, to say, he knew about the gun. He said, well, if it quacks like a duck and it talks like a duck, what is it? And Jimmy looks at him and he says, an alligator? And right then, it's heartbreaking, it really is. Because right then, that detective knew or should have known that we're not talking about a kid with normal abilities. We're talking about a disabled child. And these tactics doesn't require much. So that is how the narrator's voice changed from that of your clients, that of Jimmy's, to that of our interrogators. They told him the motive. They told him who did the shooting. They told him what his co-defendant was wearing. They told him where the gun was found, and they told him how the gun was disposed. This is not an innocence case. Not an innocence case. Jimmy did plead guilty not to murder because of this litigation. Why litigate suppression motions even when there is other evidence of guilt? Here's where I urge you to take back the fifth. It's a negotiation strategy, right? You're gonna make them work. You're gonna find out what evidence they have in a case. You're gonna educate the sentencer from the get-go. And we're back to the beginning. Coercion does not depend on the truth or falsity of a statement. It does not protect only the innocent. Take back the fifth. Thank you.